Senator from New Mexico, and we'd be glad to entertain a question if he has a question.
Yes, I want to thank my friend from Kentucky and ask him if he would to yield for a question without losing his right to the floor. And I want to start out just by prefacing this for a few minutes. From my limited experience just over the past little over 2 years on the Intelligence Committee now, I want to start by saying that there's simply no question that our nation's intelligence professionals are incredibly dedicated, patriotic men and women who make real sacrifices to keep our country safe and free. And in that, they should be able to do their jobs secure in the knowledge that their agencies have the confidence of the American people. And Congress, those of us here, need to preserve the ability of those agencies to collect information that is truly necessary to guard against real threats to our national security. The framers of the Constitution, as my colleague from Kentucky knows, declared that government officials had no power to seize the records of individual Americans without evidence of wrongdoing. And it was so important that they literally enshrined and embedded this principle in the Fourth Amendment to the Constitution. In my view, the bulk collection of Americans' private telephone records by the NSA in this program clearly violates the spirit, if not the letter, of the framers' intentions here. You know, just 6 months after my first Senate intelligence briefing, former National Security Agency contractor Edward Snowden leaked documents that exposed the NSA's massive collection of American cell phone and internet data. And as my friend from Kentucky said, not just a few Americans, literally millions of innocent Americans caught up in what is effectively a dragnet program. And it was made clear to the public that the government had convinced the FISA court to accept a sweeping reinterpretation of Section 215 of the PATRIOT Act, which ignited, in my view, a very necessary and long overdue public conversation about the trade-offs made by our government between protecting our nation and respecting our constitutional liberties. I think that well-intentioned leaders had, during the previous decade, come down decidedly on the side of national security with a willingness to sacrifice privacy protections in the process. And what became obvious was that because of our continued lack of knowledge of al-Qaeda and other terrorist organizations, some within our government believed that we still needed to collect every scrap of information available in order to ensure that, should we ever need it, we could query this information and track down U.S.-based threats. In doing so, the government ended up collecting billions of call data records, linked in case after case after case, not to terrorists, but linked to innocent Americans. Wisconsin Republican Congressman Jim Sensenbrenner, who I served with in the House of Representatives, who was one of the authors of the original underlying legislation, the Patriot Act itself, said a couple of years ago, the Patriot Act would never would have passed had there been any inclination at all that it would have authorized bulk collections, end quote. As this debate increasingly moved to the public sphere, I joined my colleagues on the Intelligence Committee, Senator Wyden, who was just here on the floor a few minutes ago, and former Senator Mark Udall, in pressing the NSA and the Director of National Intelligence for some clear examples in which the bulk information collected under this metadata program, under Section 215, was uniquely responsible for the capture of a terrorist or the thwarting of a terrorist plot. They could not provide any, not a single solitary example. Nor could they make a case for why the government had to hold this data for so long and why it needed why it had to hold the data itself and for so long. Thankfully, a review panel set up by President Obama agreed with us and recommended that the government end its bulk collection of telephone metadata. I'll admit, however, and my friend from Kentucky has brought this up on several occasions already, that I am incredibly disappointed that the President hasn't simply used his existing authority to unilaterally roll back some of the unnecessary blanket metadata collection. Some have claimed that this inaction is evidence that the President secretly supports maintaining the current program as is. That, however, is nonsense. The President has asked Congress to give him additional authorities so that he can carry out the program in an effective manner, and the USA Freedom Act seeks to do just that. Now, the Republican-led House of Representatives last week passed that bill, the USA Freedom Act, by a vote of 338 to 88, with large majorities from both parties. At a time when everyone believes we agree on nothing, large majorities of Republicans and Democrats supported that legislation. And further, the Second Circuit Court of Appeals ruling that the NSA is violating the law by collecting millions of Americans' phone records is even more proof that we've gone too far and need to recalibrate and, in my view, refocus our efforts. Why on earth, I would ask you, why on earth would we extend a law that this court has found to be illegal? Now, given the overwhelming evidence that the current bulk collection program is not only unnecessary, but also illegal, I think we've reached a critical turning point. And I want to thank my colleague from Kentucky for coming to the floor to force us all to have this conversation. We've kicked the can down the road too many times on this particular issue, and I believe it's time to finally end the bulk collection of these phone records and instead focus more narrowly on the records of actual terrorists. Americans value their independence. I know this is especially true in my home state of New Mexico, and they cherish their right to privacy that is guaranteed by our Constitution. But some of our colleagues still think it's okay for the government to collect and hold millions of private records from innocent citizens and to search those records at will. The majority leader is asking us to act quickly to reauthorize. I believe it would be a grave mistake to reauthorize the existing PATRIOT Act. And I join my colleagues in blocking any extension of the law that does not include major reforms, including an end to bulk collection. I think we can and we must balance government's need to keep our nation safe with its sacred duty to protect our constitutionally guaranteed liberties. And I guess this brings me to my question for the gentleman from Kentucky. How on earth can you possibly square what the Fourth Amendment says in terms of our papers and our ability to control our own effects without a warrant with the government's bulk collection of phone records of law-abiding American citizens?
For that great question. I think there's no way that we can square this bulk collection with the Fourth Amendment. I think part of the problem, though, is that we, over a long period of time, diminish the protections of records held by third parties. And I think one of the debates that we need to get, hopefully, to the Supreme Court sometime soon is, do you give up your privacy interest in records that are held by third parties? Because I think there will come a time that your papers that were once held in your house, there are no papers in your house. There may not be paper, but there's still the concept of records. And records were traditionally on paper, and they were traditionally in your house. But now your most private papers are held digitally by your phone, and then by the people who are in charge of the different organizations, such as phone, email, etc. And I think that there has to be Fourth Amendment protection of these. And those who look at the court cases and go back to probably the last important case, the Maryland versus Smith case, they often say there is no Fourth Amendment protection at all for these records. In fact, the government will tell you they can do whatever they want with email, with text, with all of these things. And I'm not convinced that they're not using other programs, such as this executive order program, to actually collect many other kinds of metadata other than phone calls. So I'm very worried about it. I think we need help from the courts, but we need help from the legislative body to represent the will of the people. And I think the will of the people is very clear that the majority of people think we've gone too far and that we need to stop this indiscriminate vacuuming up of all Americans' phone records, regardless of whether there's suspicion.
I would ask the gentleman from Kentucky an additional question, and I found it very helpful before I came down here today. And I want to thank you again for raising these critical issues. I went back and I read the Fourth Amendment, and I thought it'd be worthwhile just to briefly read that once again here on the floor, because I think it really puts you in the mind of some of the greatest Americans that ever lived. Our framers wrote a Constitution that has survived for well over 200 years now. It has survived Republicans, it has survived Democrats, it has survived political parties that came and went, and it has survived great conflicts time and time again. It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, shall not. And no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And I would ask my friend from Kentucky his views on the resilience of this constitutional document and how you can possibly read the actual text of this Fourth Amendment without realizing that those framers really meant for this to apply into the future to things that we hadn't foreseen yet, using the broadest terminology available in using words like effects and papers. And I would yield back, and I just want to thank the gentleman from Kentucky once again. This is one of those issues that unites people on the left and the right, Republicans and Democrats, who care deeply about our national security, but also care about our constitutional liberties. And I think the time to fix this is upon us. And without shining a light on this, we certainly are not going to be able to make the progress that we need. We have an opportunity here, and we should seize it. And I yield back to him.
Well, I want to thank the Senator from New Mexico for coming down and for being a great supporter of the Fourth Amendment. One of the things that I think is interesting is that in our current culture, we seem to devalue the Fourth Amendment. You go to, at least on our side, to all kinds of groupings and gatherings, and there's a lot of talk of the Second Amendment, there's talk of the First Amendment, but there hasn't been so much of the Fourth Amendment until we got to this point where the collection of data seemed to be run amok. But one of our founding fathers was George Mason, and he was considered to be an anti-federalist. He was a guy who really stood on principle, but he was also a guy that had the audacity to actually not sign the Constitution, even though he was asked and he was there and could have. And on September 17, 1797, he refused to sign the Constitution and returned to his native state as an outspoken opponent in the ratification contest. His objection to the proposed Constitution was that it lacked a Declaration of Rights. Mason felt that a Declaration of Rights, or what we call a Bill of Rights, was a necessity in order to curb federal overreach. Mason, though, was also famous for being an author of the Virginia Declaration of Rights, which was written a decade or so before our Constitution, and upon which many things were based. He wrote in the first paragraph of the U.S. Declaration of Independence something that is similar to what you hear in the Declaration of Independence. He wrote, "All men are by nature equally free and independent, and have certain inherent rights of which, when they enter into a state of society, they cannot, by any compact, deprive or divest their posterity, namely the enjoyment of life and liberty, with the means of acquiring and possessing property, and pursuing and obtaining happiness and safety." In the Declaration of Rights, which comes from 1776 for Virginia, he also was instrumental in including Article 9. Article 9 is basically the precursor to the Fourth Amendment. And in he wrote that general warrants whereby an officer or messenger may be commanded to search suspected places without evidence of a fact committed, or to seize any person or persons not named, or whose offense is not particularly described and supported by evidence, are grievous and oppressive and ought not to be granted. So from the very beginning, the Fourth Amendment was a big deal. It was a big enough deal that the fact that it wasn't included caused George Mason to say he couldn't sign the Constitution. It was a big enough deal that this debate went on for a while, and finally the resolution of getting the Constitution included that there would ultimately be a Bill of Rights. Thomas Jefferson wrote about the Bill of Rights. He said, "A Bill of Rights is what the people are entitled to against every government, and what no just government should refuse or rest on inference." I like the way he put it. A Bill of Rights is what the people are entitled to against every government. It's a protection. Jefferson also described the Constitution as the chains of the Constitution. The chains were to bind government and to prevent government from abusing its authority. When we've adhered to this, when we've paid strict attention to it, we've maximized our freedom. When we've let our guard down, when we've allowed our guard to stray away, when we've allowed the government to usurp authority, to gain and grab and take more power, it's been at the expense of freedom. I think we can be safe and have our freedom as well. I think we can obey the Constitution and catch terrorists at the same time. I think, in fact, frankly, strictly from a practical point of view, I think we gain more information by using the Constitution. By having less indiscriminate collection of data, and by having more collection of discriminating data, data that's based on suspicion, data that's based on tips, data that's based on human intelligence, data that we can focus all of our human energy on, I think we actually will catch more terrorists. I think there's been instance after instance after instance where we did have information on terrorists and we failed to act. Perhaps because we're spending so much time and so much energy on the indiscriminate collection of data. William Brennan was one of our famous justices, and he said of the framers, he said, "The framers of the Bill of Rights did not purport to create rights. Rather, they designed the Bill of Rights to prohibit our government from infringing rights and liberties presumed to be pre-existing." We didn't create the rights. Government didn't create your rights. Your rights come naturally to you. For those of us who believe in a creator, they come from our creator. But they're important to protect. They should be protected against all forms of even majority. It's why some of us are very important to say that we are a republic. We're not a democracy. That no majority should be able to take away our rights. And that's why this is important. I think that these questions ultimately get to the Supreme Court. Because no matter what the majority says here, no matter what the majority of the legislature says, the Bill of Rights lists and codifies rights that cannot and should not be taken away from the majority, by a majority. The rights that we have to be left alone. As Justice Brandeis said, the most cherished of rights, the right to be left alone. But this debate is a long and ongoing debate. For nearly 100 years, from the Olmstead case in 1928 to the present, we've had a discussion and a struggle and a controversy over what parts of our conversations are to be protected and what parts are not to be protected. I think a lot of our problems really originated with going the wrong way in 1928 with the Olmstead case, because we went for a long period of time. We went for 2 generations thinking that your phone calls were not private and that your phone calls were not protected by the Fourth Amendment. And then we finally get to the 1960s and we reverse that and we say your conversations are to be protected, but within a decade, we make the wrong decision again and say that your records are not to be protected, that your Fourth Amendment, your records once held by the phone company aren't to be protected. I think that was a mistake. I think it's also a mistake to think that we're literally talking about paper in your house, because there's quickly coming a time in which technology will be such that there will be no papers. Papers will be another word for records, but your records will not be kept in your house. They already aren't. There was a discussion of this, in whether or not we can search a person's individual phone, and the court did rule, I think, in an accurate way. The court said, and one of the justices said, that basically the information found on your phone is more personal and more extensive than probably any papers that were ever in any home in a time before electronics. So we are going to have to catch up to electronics. We're going to have to catch up to a digital age, and we're going to have to decide, does the individual maintain a privacy interest and or a property interest? I frankly think that when the phone company holds my records, that they're partly mine, that there's a property interest and a privacy interest that I haven't relinquished. Unless I've given explicit permission, I don't think that I've given up my privacy. I don't think I've given up, and in fact, many times it's the opposite. Many times what we've actually said is, when I agree to do banking with you, or I agree to have you hold my telephone calls, or I agree to do internet searches with you, I have an explicit agreement often. The agreement is so explicit to defend my privacy that when they don't, they're actually fearful of being sued. And so all of this craziness, all of this overreach, all of this loss of our privacy comes with a little additional caveat that's written into all the laws and everybody's clamoring for, and it's what they want now: liability protection. They want to be able to violate their privacy agreement, so we give them liability protection. They don't want to be sued, but they realize they're violating and could be accused of violating our privacy agreement. So as much as I hate and despise frivolous lawsuits, the threat of suing somebody causes them to obey their contract. If they don't have the threat, if you say, well, we're going to have contracts, but we're not going to enforce them with the threat of a lawsuit, then contracts become meaningless. And so it's really important that as we move forward, we try to say to people, the privacy agreement you sign is a real document, it's a real contract, and it should be protected. When referring to the Bill of Rights, General Smedley Butler, who was a 2-time Medal of Honor winner and a Brevet Medal of Honor winner, said, there are only 2 things we should fight for. One is the defense of our homes, and the other is the Bill of Rights. When I've talked to the young men and women who have fought bravely for our country, young men and women who have lost limbs, the families of those who have lost lives, that's what I hear from every one of them. I hear from them that they were fighting to defend the Bill of Rights. They were fighting to defend our Constitution. What saddens me is that while they were fighting for our Constitution, while they were fighting for our Bill of Rights, their legislators weren't fighting for the Bill of Rights. Their legislators were turning the other way. Their legislators were so fearful of attack that they gave up on the Bill of Rights and said, Here's my liberty, just give me security. This is a long-standing debate. Franklin had it right. Those who are willing to give up their liberty may end up with neither. Now, some would ask, why am I here today? What do I propose to get out of this? Is there an end point when I'll go home and be quiet and quit talking about the Bill of Rights? I think there could be. I think if the leadership of both parties in the Senate would agree to have a debate on the Patriot Act, if they would agree to have amendments and have votes, and I'll give you some examples of some things that we think. Most of these will ultimately be introduced in all likelihood by Senator Wyden and I. I'll start with the first one, and this is based upon an amendment that he and I have worked on together. This amendment would prohibit mandates on companies that alter their products to enable government surveillance. So this amendment prohibits any mandates from government agencies requiring private companies to alter their security features, their source code, to allow the government to get into their stuff and into your lives. This amendment would apply to computer services, hardware, software, and electronic devices made available to the general public. Currently, the government is requiring, and sometimes telling companies they can't even tell you this, they're requiring access to certain products. There have been stories of them inserting malware on Facebook, giving you access to Facebook, and then getting into your Facebook account through the Facebook code source. I know Facebook has objected to this and fought them on this, but our amendment would say that the government just can't do this. The government cannot force different social networking sites and different internet software. It cannot force them to give the government access indiscriminately. The question would be, can the government require things specifically? Absolutely yes. Present evidence and get a warrant, and realize that when they want to make you so afraid that you give up all your records, realize that warrants aren't hard to get. The FISA warrants are almost without question agreed to, maybe to a fault. 99% plus of all the warrants ever requested are granted. I think it's not too much of a step to say that we should ask and request warrants. The Second Amendment that we would consider putting forward if we were allowed to and allowed to have votes on would replace the Patriot Act extension with comprehensive surveillance reform. We would replace the extension of expiring authorities with substantial reforms as originally proposed by Senator Wyden and Paul and others in the Intelligence Oversight and Surveillance Act of 2013. This amendment would end bulk collection and replace it with nothing. We would close the Section 702 backdoor search loophole, which allows the government to say they're searching foreigners' records, but to in reality gather up 90% of the records being American records and called incidental. We would close this backdoor loop where actually American records are being collected, not foreign records. We would create a constitutional advocate to argue before the FISA court, before the intelligent court. The reason I think this is necessary is that the court has somewhat become a rubber stamp for the government, and we aren't allowing any kind of opposing arguments, and we're really not even having any argument. So, for example, we've loosened the standard from the constitutional standard, which is probable cause, and we've said it's relevance. So we get to relevance, but when you come before the court, I don't think anybody's debating or being asked to prove whether it's relevant or not. Certainly they must not, because they're somehow proving the collection of everybody in the United States' record, which I don't know of anybody who believes that the word relevant could include everybody. So if we had an advocate or we had someone to say, this is the other side, I think it's really important. I'm not a lawyer, but I understand they argue with each other all the time. You're supposed to figure the truth out. And you argue and advocate for your side, and then somehow you arrive at a truth, or people arbitrate what they think the truth is from this discussion. If only the government argues, you can't get even any sense or form of what truth is. So what we would argue in our Second Amendment is that we actually have an advocate that argues on that side. I would go further, though, and say that not only do you have an advocate, you should have an avenue for appeal. I'm with Senator Wyden, and I want to protect all the people doing this. I don't want any names revealed. I don't want any agents revealed. I don't want to endanger the people who are risking their lives for our country to gain intelligence. But I do think that the law in general can be debated. Senator Wyden talked about how the law doesn't need to be secret, the operations need to be secret. So you can protect all of that. But I think the law should be debated. And for example, the question now whether or not you have any privacy interest in your third-party held records, whether the Fourth Amendment protects these at all, that's a constitutional question. That should not be decided in secret, and you really can't have justice decided in secret. The other part of our amendment would give Americans spied on by the government standing to sue in court and end the practice of reverse targeting, under which the government targets the communication of an American without a warrant by targeting the non-U.S. person they speak to. By some reports, it's even worse than that. I mentioned earlier that an enormous amount of what the PATRIOT Act does, which was supposed to go after foreigners, is actually being used domestically for drug crime. There have been reports that the information is being gathered through an intelligence warrant, and then they go back with a traditional warrant after they've gotten the investigation through a lower standard, through a non-traditional, non-constitutional investigation. Then they go back and they get the warrant after using this information, or they recreate the scenario in order to get the information they need, and then they don't tell the judges they got the information through the intelligence angle. Another amendment that we would like to ask the leadership of both sides if they will let us introduce, if we're allowed to debate this and have an open amendment process, would be that warrantless spying cannot be used against Americans in non-terror criminal cases. This was originally the way it was, and this is why you have to worry about the slippery slope. Back in the 70s, they said, okay, we're going to have a different standard to get foreign terrorists. And even myself, who wants to keep good standards, can accept a little bit of that, a slightly lowered standard for people who don't live here and aren't American citizens and aren't part of our country. It has its dangers, but even I might be able to accept that. But what I can't accept is that you lower the constitutional standard, you're going to use a terrorist warrant that has a lower procedural hurdle, and then you're going to use it for domestic crime. That's exactly what's going on now. We should be appalled that they destroyed the Fourth Amendment for certain crimes, and we just didn't do anything about it. Section 213 of the PATRIOT Act is called sneak and peek. The government can go in your house and never tell you they were there. They can look through all your records. They can steal stuff. They can replace it. They can do all kinds of things. Place listening devices, all without ever telling you. This is in contradiction to what most people have accepted the Fourth Amendment to be. But if you look at who's being convicted with Section 213, 99.5% of the people are for drugs, for domestic crime. So what we've done is we've taken a domestic crime and we say the Constitution no longer applies. We basically got rid of the Fourth Amendment for these crimes. So for about 11,000 people a year, the Constitution no longer applies to them. We're using a lower standard. Now, if you want to make this even worse, think about who's being convicted of drug crimes in our country. 3 out of 4 people being convicted of drug crimes in our country are black or brown. But if you ask who are the kids that are using drugs, equal numbers of whites and black kids are using drugs. But 3 out of 4 people in jail are black or brown. And then you find out that not only have we messed up the war on drugs such that it has a racial element to it, we now are using a lower standard that's not the Constitution, and the end result is a racial outcome. This is an enormous problem. I mean, related to so much of what's going on in our country, so much of the anger you're seeing in our cities comes from this injustice. So you now have people going to jail. You have people going to jail for 15, 20, 30 years. There's a woman by the name of Mary Martinson from Mason County, Iowa. Her mother just died recently, and they let her out of prison for a couple of hours. Her dad's getting older, and she wishes she were there to help her parents. Now, she did mess up. She was a drug addict. Her boyfriend was a drug addict. They had guns in the home. He was selling the drugs. She was a meth addict. She was probably going to die if she stayed on the drugs. So it was good she got off the drugs. But she got caught. She got 15 years in prison. You can kill somebody in Kentucky and be out on parole in 12 years. And yet we put this woman in there for an addiction. We put her in jail. She'd never, ever been convicted of any other crime. No judge in their right mind would have ever given her 15 years. Nobody would have. The judges basically are telling the defendants and telling the press, I would never do this. This is the wrong thing to do, but I am forced to do this. Compound this with the fact that the war on drugs has had a racial outcome. So you compound and put the two together, and you say, well, we're no longer obeying the Constitution and there's a racial outcome. Where's the hue and cry? Where's the president on this issue? I've talked to the president about criminal justice. I think he sincerely wants to help. But here's the thing. The president could today stop this program. He could stop collecting stuff through the sneak and peek. He could say we're no longer going to do the bulk collection. Most of these things originated out of executive order. He could stop these anytime he wanted to. We would stop it. We would say no more spying against Americans and no more use of this information for non-terror criminal cases. We have another amendment that goes to the heart of what I think should be decided by the Supreme Court. And in this amendment, we call this the amendment that would protect the privacy of Americans' records held by third parties. I think that your records, that you do retain a privacy interest. In this amendment, should the leadership agree to allow us to have amendments, this amendment would establish a clear principle consistent with the Fourth Amendment that as it relates to government collection, an individual's records given to a third party for a specific business purpose are equally secure in their person as those that remain in their possession, unless that third party informs the individual that it intends to share the information. This amendment affirms that the government cannot circumvent warrant requirements by taking Americans' records from third parties, and it protects the constitutional rights during engagement in regular communication and commerce. I think we had a vote on this a while back. I think we weren't that successful. I think we got 4 people to vote to say that your records should be protected by the Fourth Amendment. Most people don't really realize this. Most people have no idea that the government's position, and currently maybe the Supreme Court's position, is that you don't have any Fourth Amendment right in your records, unless you've got them in your house. And I think this is something that the more people understand it and the more people are drawn to this issue, maybe people will demand that we have some justice here, that we live in an era where ultimately no one is going to have paper records in their house. All of your records are going to be electronic. And because they're held and they're managed somehow by a third party, does that really mean we've given up our rights? See, the thing is the government might say if your cell phone's in your house, then they do, but the cell phone's connected to someplace outside your house. So your email is being stored on some server somewhere. I see no way that it could be construed that you've given up your right to privacy because someone else is holding the records for you, because that's the way in the digital age we've come to hold records. We talked a little bit earlier about trust, and I think trust is incredibly important. I don't discount that the vast majority of people who work in our intelligence community are honest, trustworthy, patriotic. I think we all want the same thing. We want to protect our country. We want to protect our loved ones. We want to, honor the memory of those who died on 9/11 by capturing and stopping the people who would attack us. But the question is, can you catch more or less, or are we more or less effective in catching terrorists if we use the Constitution, if we use traditional warrants? And I think without question, if you talk to people, they'll tell you that they get a great deal more information and more specific information by using warrants. Let's say tomorrow that there was a president, that we elected a president that eliminated the bulk collection of data. Let's just say it happened. What do you think would happen? People are like, oh, the sky would fall, we'd be overrun with jihadists. Well, maybe we could rely on the Constitution. Maybe we could get warrants. The information's out there. There are warrants. If you make the warrant specific, there's no limit to what you can't get through a warrant. The warrants are given the vast majority of the time. People complain and they say, oh, it'd be taking too long, it'd be inconvenient. Make it better then. Put your judges on 24 hours a day. Appoint 24 more judges and put them on call all the time, and let's do this. There's no reason why you can't have security and liberty at the same time. Another amendment we have, should the leadership agree to allow us to have amendments and to have votes and to have a debate on this, is an amendment that would require the court to approve national security letters. In a 3-year period between 2003 and 2006, 140,000 national security letters were given out. So national security letters are warrants that are below the constitutional bar. They don't meet the constitutional bar because they're not being signed by a judge. They're being signed by the police. So you get rid of one of the great protections we had, which was the check and balance that the police would always go to the judiciary. It was a different branch. The judge is sitting at home reasonable, hopefully in a reasonable fashion. The judge isn't in hot pursuit. The judge isn't letting their emotions. The judge wasn't just punched by one of the convicts. The judge is sitting home in a reasoned fashion trying to make a reasonable decision. But still, the vast majority of the time, warrants are given. So if there is a policeman outside the house of an alleged rapist and they want to go in, they call on a cell phone. The judge almost always says yes. Same for murder. Does anybody imagine that there would be a judge in our country that you call them and you say, John Doe, we have evidence that he traveled to Yemen last year. We have evidence that he talked to Joe Smith, who we have evidence is a terrorist, and we want a warrant to tap his phone. Look, I'm the biggest privacy advocate in the world. I'll sign the warrant immediately. I don't know of anybody that's not going to sign warrants to allow searches to occur. But you have the check and balance so it doesn't get out of control. What happened and what's happening now is we let down our guard. We have no checks and balances. And so what's happened is, what does the government do when you're not watching? If you look away, the government will abuse their power. Lord Acton said that power corrupts and absolute power corrupts absolutely. The corollary to that would be that power grows, and when you're not watching, power grows exponentially. And they will do whatever they can get away with. They will do it in the name of patriotism. And actually, I don't even question their motives. They believe themselves to be patriotic, but they think that we have to do anything that it takes, no matter whether it contravenes the Constitution or it contravenes the Bill of Rights. The people who do this, their motives are good, but they're confused in the sense, and they don't quite fully comprehend what we're giving up in the process. This amendment would require judges to sign national security letters. It would make them more like warrants. In practice, national security letters have become warrants written by law enforcement without prior court review and approval, granting them almost unfettered access to individual email and phone communication data, as well as consumer information such as bank and credit records. Those subjected to the national security letters must also obey a gag order. So not only does the government come to you with a less than constitutional permit, a less than constitutional warrant, they then tell you can't talk about it. You might go to jail for 5 years if you tell somebody you've had a warrant served on you. This amendment would require that a government obtain approvals from a court prior to issuing an NSL to a private entity, thus forcing them to demonstrate a clear need for information as part of an investigation. Amendment 6 would create a new channel for legal appeals for those subjected to government surveillance orders. This amendment would empower individuals or companies ordered by the government to hand over information about users or customers to make constitutional challenges in order to be in order in the U.S. Court of Appeals. My understanding right now is it's very difficult to appeal a FISA order. They're secret. You're not allowed to be in the court, so you're really not allowed to participate in the process. I think also you can get outside of FISA by appealing, but I think you have to ask for something that's called a writ of certiorari. It's a special condition, and it's not so automatic. And so my understanding is that the court will grant these things, but they don't occur very often. They're an extraordinary thing. And so what we would like to make it is a little bit more of the facility of getting to a normal appeal, the way a normal appeal would occur. And so we've been pushing to allow that there would be more of an automatic sort of appeal here. One of the other amendments would say no liability immunity for companies that break their agreements with users. And like I said, while I'm not in favor of lawsuits and I don't like the idea of frivolous lawsuits, I think if you don't protect the contract, if you have a privacy agreement that says they're not going to share your information with anybody, the only way they'll protect it is if there is the threat that they could be sued for not protecting it. I think the contracts become not worth the paper or the click that I agree to this. It becomes completely worthless if the companies are told that they can go around it. The companies have all specifically requested this because I think they fear that every day the government is requesting them to breach the privacy contract. So in order to enable the privacy contract, I think we have to get to a point where people can sue if their privacy is violated. One of the things, and I think there can be a mixture of opinions on, what Snowden did. I think that we have to have secrecy, and there have to be laws against revealing secrets. So I can't say we should have everybody revealing secrets. At the same time, I think the law says that those who are reporting to Congress should tell the truth. So we have the intelligence director lying to us and saying the program doesn't exist, and then we have someone committing civil disobedience. But when you commit civil disobedience, it isn't that we change the law and say it's okay. What we do is we say, you broke the law, and maybe you did it for a higher purpose, but it doesn't mean we will or get rid of all punishment for things like this. I do think, though, that there is one way that we could modify it. Snowden was a contractor, and we don't have very good rules for whistleblowers who are contractors. I would extend the whistleblower statute for people who want to come in and want to tell an authority, an investigator general or somebody, if they want to reveal that they think something is being done illegal. For example, if Snowden knew that Clapper was lying, a felony has been committed. I would think that somebody who has evidence of a felony that tells the investigator general, look, I have seen this, and I have seen that they're collecting all American records of every American, and he says they're not. He's committed perjury and a felony. There ought to be some sort of whistleblower statute for that. So what we do in one of our amendments is to allow whistleblowers to be contractors as well. One of the things that's been going on, even predating PATRIOT Act, goes back probably into the 80s and 90s, is something called suspicious activity reports. These are now being done, I believe, by the millions. Okay, I think at one point a couple years ago when I looked at it, it was 5 million of these have been filed. So hundreds of thousands every year are being filed, and if the banks don't file them, the bank could have their license taken from them or $100,000 loans given to $100,000 fines given to banks. So what we'd like to do is to make a suspicious activity report based on suspicion, not just based on a transaction. So we'd make it more like a warrant where a judge would actually review it and see if there's suspicion to be reporting this activity instead of just reporting activity based on the way people do their transactions. The problem has been is we now have the IRS confiscating your money, your bank account, based on the way you make your transactions. So it's not based on a conviction. It's based on, I guess, the presumption that you are guilty until you can prove yourself innocent. This is also going on with civil asset forfeiture. So it's intertwined with records, and as we allow the government to collect our records in an unconstitutional manner, we have to be very careful that then those records are being used with the presumption of guilt, not innocence. There's a great deal of question I have over Executive Order 12333. There are some that maintain John Napier Ty was with the State Department and overseeing some of the freedom of the internet and government surveillance. And he's put out an op-ed that shows a significant concern for whether or not this executive order may be as big as bulk collection. I spoke with one of the founders of one of our America's larger internet companies recently, and he told me not only is he worried about bulk collection, but he's worried that bulk collection might be smaller. The collection of all our phone data might be smaller than the backdoor collection through 702 and the backdoor collection through the government forcing companies to allow them into their software. And so our concern is that we need to look more at the executive order. I think it's being done in secret. But once again, an evaluation of whether a law is constitutional or not, or whether a law overstates its purpose, should be done in the open. I see the senator from Montana, and I'd be happy to entertain a question without losing the floor.
Will the senator from Kentucky yield for a question without losing his right to the floor?
Yes.
I want to thank my colleague for raising this important issue on the Senate floor today. You know, it wasn't all that long ago that as a House member, because I served one term in the House and then came over to the Senate this year. I came over to the Senate floor and I stood in support of your efforts to protect the American civil liberties and ensure that drones aren't being used to target American citizens on our own soil. And in fact, I'm grateful to see that in the Senate chamber today, we have 5 House members who are here standing with the senator from Kentucky as he's making this very, very important point as relates to our Constitution and our freedom. Well, 2 years later, we're here again, and the threats to America's civil liberties and constitutional freedoms remain ever present. As my colleague from Kentucky is well aware, I spent more than 12 years in the technology sector before being elected to Congress. I know firsthand the power that big data holds. I also know the great risks that arise when this power is abused. There is a clear and a direct threat to American civil liberties that comes from the mass collection of our personal information and our phone records. I, like so many Montanans, are deeply concerned about the NSA's bulk metadata collection program and its impact on our constitutional rights. In fact, just last night, I hosted a telephone town hall meeting with thousands and thousands of Montanans. And one of the issues I heard most about was the NSA's bulk data collection program. And when is Congress finally going to put a stop to it? In fact, this is one of the issues I hear most about from my fellow Montanans. In fact, I've brought down just a few of the thousands of letters I've received from Montanans on the NSA's dangerous bulk metadata collection program. For example, here's Adam from Missoula. Adam writes, "I'm writing to ask you to allow Section 215 of the PATRIOT Act to expire on June 1st of this year. While it's only one provision of the larger problem, it would at least begin to curtail the surveillance of Americans. As Americans, we should be free to communicate without the threat of the government monitoring those communications. Wanting to hide your life, to keep your life private, does not mean you have something to hide. Only that your life isn't any of the government's business as long as you're not infringing on the liberty of others. At the end of the day, giving up our liberties because of the threat of terrorism truly is the definition of terrorism winning. To be free inherently means a person also incurs risk." Even though he was speaking about taxes, I believe Benjamin Franklin would agree when he said, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." Jess from my hometown of Bozeman, Montana, wrote this: I am writing to you as your constituent. NSA spying needs a comprehensive overhaul. But in the meantime, I urge you to show that you care about the Constitution by voting against reauthorization of Section 215 of the USA PATRIOT Act. Section 215 has been used to invade the privacy of millions of people. Although some in Congress and the NSA have argued that collecting call detail records, quote, metadata, is not privacy invasion, the information collected by the government is not just metadata. It paints an intimate portrait of the lives of millions of Americans. What's more, the collection of call detail records isn't even necessary to keep us safe. The President, the Privacy and Civil Liberties Oversight Board, and the President's Review Group have all admitted that collection of call detail records is not necessary. In fact, the Privacy and Civil Liberties Oversight Board went so far as to note that it could not identify a single time in which bulk collection under Section 215 made a concrete difference in the outcome of a counterterrorism investigation. That's why I urge you to support reform by committing to a no vote on the reauthorization of Section 215. A vote against reauthorization is a vote for the Constitution. Thank you for opposing unconstitutional surveillance and for supporting a free and secure internet. You know, Montanans are right to be concerned. This program is a direct threat to our constitutional rights. It has jeopardized our civil liberties with little proven effectiveness. And I'm the son of a U.S. Marine. Several weeks ago, I was with Leader McConnell and other senators. When we went to Israel, we met with Prime Minister Netanyahu. We went to Jordan and met with King Abdullah. We went to Iraq and met with Prime Minister Abadi. We were both in Baghdad. We went up to Erbil and met with the leaders of the Kurds, including Mr. Barzani. We then went to Afghanistan. We were in Kabul. We were in Jalalabad. We met with President Ghani. We were hearing directly from the leaders in the Middle East. We were hearing directly from our U.S. military. We were hearing directly from U.S. intelligence about what's going on in the Middle East. As a father of four, someone who believes strongly in a strong national defense and the importance of protecting the homeland, I weigh these issues very, very deeply. These are heavy issues we must look at as we want to ensure we protect the homeland, but importantly, protect the Constitution and the constitutional rights of the American people. As my colleague is likely aware, a 2014 report from the Privacy and Civil Liberties Oversight Board, which is a nonpartisan, independent privacy board, found that the NSA's bulk data collection program, and I quote, said contributed only minimal value in combating terrorism beyond what the government already achieves through other alternative means. And like the New York-based Second Circuit U.S. Court of Appeals recently unanimously confirmed, this oversight board also found that Section 215 of the Patriot Act does not provide authority for the NSA's bulk metadata collection program. In fact, the report states, and I quote, under the Section 215 bulk telephone records program, the NSA acquires a massive number of calling records from telephone companies each day, potentially including the records of every call made across the nation. Yet Section 215 does not authorize the NSA to acquire anything at all. It's illegal. It's an overreach of power. And it's a direct threat to our First and Fourth Amendment rights. In fact, the report goes on to conclude, and I quote, the program lacks a viable legal foundation under Section 215. It implicates constitutional concerns under the First and Fourth Amendments. It raises serious threats to privacy and civil liberties as a policy matter, and has shown only limited value. For these reasons, the government should end the program, end quote. I stand here today with the people of Montana. I stand here today with my colleague from Kentucky. I stand here today with 5 members of the U.S. House who are seated in the back of the Senate chamber. Congressman Duncan of South Carolina, Congressman Blum of Iowa, Congressman Massey of Kentucky, Congressman Labrador of Idaho, Congressman Amash of Michigan. You know, I think it's important that the Senate recognizes what the People's House did last week when they passed the USA Freedom Act. That vote was 338 to 88. And to suggest that this is just a small minority of congressmen and women that support the USA Freedom Act, this was the chairman of the Judiciary Committee, the chairman of the Intelligence Committee, the chairman of the Armed Services, the chairman of Homeland Security, amongst many others who want to ensure we strike the right balance between protecting the homeland and protecting our civil liberties. The people of Montana, my colleague from Kentucky, the 5 members of Congress who are here at this moment, and millions of Americans know that I strongly agree with their view on the USA Freedom Act. Now, like all Americans, I understand the great risks facing our national security. The threats of ISIS, the threats of North Korea, the threats of Iran grow stronger each and every day. And we must be prepared. And we must ensure our intelligence and law enforcement agencies have the tools they need to protect and defend our nation. But these objectives, national security and protection of our civil liberties, are not mutually exclusive. We can and we must achieve both. We must maintain a balance between protecting our nation's security while also maintaining our civil liberties and our constitutional rights. All of us standing here today took an oath to protect and defend the Constitution. I took that oath just a few steps away from speaking here today between myself